the first to know Nsem-Pii TV.
Anra na ukopie mu ewo mmrahye na enye asem kotwa sene video no eba beto abonten no enye na dom kuma no bonyina ashe black abon etimi ekrekre pipa say clerk krata a ono ede akwakoma isi se Pandai seat no yen declare vacant no enya ade se won ebeje atum me no kasa de wo reason no simple say asem no after Temale High Court etimi the judgment eba no one de akwakopie mu ewo appeal court sanso na asem no akwakopie mu ewo Supreme Court these two court nyina etimi serve notice to Parliament say asem no aba be pie mu ewo ho enti aba ne say na clerk of Parliament de ahopepre etwere krata the kokoma EC ewa bra nsa etimi eka court document on 1st December ewa bra up to now nyina onka ho asem ene dom kuma no etimi aye press conference na appeal court decision no ade se ene na won ebeteki me kire ene na appeal court etimi ebetena asem ne so dom kuma ne still baby a won edina na wodina until say appeal court and Supreme Court one decision beba no enya ade se won ebeti ase near declare Pandai seat no vacant na ode yenko na enkonkotie Nsem-Pii adom kuma no eka one press conference ni
direct assault on the constitutional rights of the people of Pandai, a dangerous breach of the separation of powers and a redress and a reckless disregard for both our judicial process and our own parliamentary history. This House is on the verge of committing a constitutional travesty and a historical self-betrayal. We have taken note of a formal communication from the Clerk of Parliament issued pursuant to the contested High Court order notifying the Electoral Commission of a vacancy in this honorable House. On the strength of that notification alone, the Electoral Commission is expected to regard the Pandai parliamentary seat as vacant, though it is a seat that was decisively won by the New Patriotic Party with a clear and commanding mandate of a difference of 3,734 votes. But here is the profound constitutional and historical defect at the heart of this matter. As I stand before you, the Honorable Member for Pandai, Matthew Nyindam, has duly exercised his constitutional rights. He has filed a stay of execution, halting by the operation of law the effect of that very judgment. 2, he has lodged a notice of appeal to the Court of Appeal. And 3, he has initiated an application for certiorari at the Supreme Court. I ask, what manner of parliament are we in that we would rush to enforce a judgment that is legally suspended, ignore appeals that are actively proceeding, and arrogantly presume to be preempt our superior courts before they have uttered a single word? Worse, why are we abandoning the wise and restrained precedents set by this very House? Let us consult our own ledger. Our institutional history reveals a consistent bipartisan practice of protecting a member's mandate until the legal process is conclusively settled. We have never treated a contested first instance order as an immediate death warrant for parliamentary tenure. Let me cite specific examples. In the case of Samuel Nyemekan of Welensee, after the High Court voided his election, he filed an appeal. What did this House do? It continued to recognize him as a sitting MP throughout the entire appeal process. The seat was only declared vacant after the Court of Appeal delivered its final judgment. In the case of Eric Amwating of Nkranza South, detained abroad on serious charges, this House resisted calls to declare his seat vacant while his legal status was unresolved. Vacancy occurred only upon his own properly executed resignation. In the case of Danawodapi of Keta, convicted and sentenced to 10 years imprisonment, this House did not treat the conviction as an automatic trigger. When circumstances allowed, when he was granted a presidential pardon, he returned to this chamber on 10th of June 2008 and was permitted to sit and perform duties as MP. His tenure ended with the dissolution of Parliament. In the case of Adamu Dramani Sakanda of Boko Central, the honorable member continued to serve in Parliament for years while the courts determined civil challenges to his eligibility. It was upon his final criminal conviction and subsequent imprisonment in July 2012 that he became legally incapacitated from performing his duty as a member of Parliament. Even as he pursued an appeal, he was granted a presidential pardon in December 2012. In any case, a by-election could not have been constitutionally justified since his incarceration occurred less than 6 months before the 2012 general election. Let me address the case of James Jechi Quayson, which is often mentioned. A clear look at what actually happened shows why rushing on Pandai is wrong. Here are the facts. Quayson was sworn in and served as MP in January 2021. Even though a court case was already pending, Parliament allowed him to work, just as we have done in other cases. In July 2021, a High Court nullified his election, but even then, Parliament did not immediately declare his seat vacant. The real change came from the Supreme Court. In April 2022, the Supreme Court issued a direct order, an injunction commanding Quayson to stop acting as an MP. And in May 2023, the Supreme Court gave its final judgment, ordering Parliament to remove his name. The lesson is clear. Parliament's decisive action in the Quayson case was not based on High Court ruling alone. It was based on specific final orders from the Supreme Court. Now compare this to Pandai. Today, we have no order from the Supreme Court. We have no injunction. Instead, we have a High Court ruling that has been formally stayed and is under appeal. To use the Quayson case to justify instant action in Pandai turns the truth upside down. Quayson's case teaches us to wait for the Supreme Court's final word. In Pandai, we are ignoring that lesson and acting before the first appeal has even been heard. We cannot use a case that required court intervention to justify acting when the Supreme Court has not spoken at all. The pattern, therefore, Mr. Speaker, is undeniable. This House has always required one of three conditions: the exhaustion of appeals, a final specific order from the Apex Court, the member's own resignation. Article 99 1E of our Constitution is precise. A seat becomes vacant upon a determination by the appropriate judicial authority. Our history proves that a determination is not the first word of the High Court. The final authoritative word after the appellate. Our history proves that a determination is not the first word of the High Court, but the final authoritative word after the appellate process is complete. Our legal system is built on this foundation. The right to appeal is a fundamental pillar of justice. Yet this House is being urged to treat a suspended, appealed, and contested High Court order as the final irrevocable command. This violates the Constitution and repudiates our legacy of institutional restraint. Let us be unequivocally clear by acting now. We are not following precedent. We are shattering it. We are declaring that for the people of Pandai and for Honorable Matthew Nyindam, the historical respect for the process and appellate right is null and void. We are telling the 363,734 citizens whose clear will is not in mathematical doubt that their vote is expendable. We are telling Honorable Nyindam that his constitutional right to appeal, a right exercised by Nyamekan, Sekunde, and Quayson, is meaningless. We are telling the Court of Appeal its pending task is irrelevant. This is not upholding the law. It is a selective, cynical, and historical illiterate application of it. If we proceed, we do not wrong Pandai today. We establish a toxic new rule for tomorrow, that a parliamentary majority can weaponize a first instance court order to instantly unseat a political opponent, rendering the appellate courts and our own historical practice obsolete. Therefore, the duty of the House is clear. We must, one, acknowledge that a stayed and appealed judgment cannot be considered a final determination, as our history with Dan Abu Dhabi and others confirms. Number two, we defer any action until the appellate process is conclusively complete, respecting the precedent set across decades. And number three, we need to recognize that this premature notification violates the separation of powers, disrespects the judiciary, unjustly disenfranchises the people of Pandai, and betrays Parliament's own tradition of constitutional caution. And finally, number four, need to withdraw the notice of the Electoral Commission to the Electoral Commission immediately. This is not a partisan plea. It is a call for basic constitutional fidelity and historical consistency. In conclusion, I stand here for the rule of law and for the sanctity of our parliamentary traditions. The notification on Pandai is historical aberration. It is a violation of the separation of powers. It is a usurpation of appellate jurisdiction. a disenfranchisement of Pandai voters, a denial of Honorable Matthew Yindam's rights, and a gross departure from our own settled practices. Accordingly, I submit that this House is constitutionally, legally, democratically, and procedurally bound to withdraw the premature notice issued to the Electoral Commission. Let history record that this Parliament chose the wisdom of its past precedents of Nyamakan, Abu Dhabi, and Moating over the rashness of partisan expediency. Respect the stay, await the appeals, honor our history, uphold the Constitution. The people of Pandai are watching. Ghana is watching. History is watching. Thank you very
much. The minority continue in the stance that government business will suffer if this letter is not withdrawn. And secondly, the chief whip on the majority side say that they are going to refer all of you to the Privileges Committee for the conduct yesterday. How do you respond to this question?
I think we have been very clear in our demands. I don't think that this one, the statement is very clear in all our demands.
The Privileges Committee.
That one, I don't know how it could be. Yes.
We're done.
Thank you.
Thank you very much, guys.
So the legal counsel to the minority, let me speak to you very briefly on some of the issues that have come up, if you don't mind. The NDC's position is that the mere filing of an appeal will not be a stay of execution. It cannot act as a stay of execution. And so they do not understand why you want that to happen. In fact, some of them are citing instances like what happens on the 6th December if someone files an application for injunction on an election. Does that stop the election from happening? That surely is solid legal grounds.
But I think that the case we've made is clear. What our leader said is very clear. The case is not over. It's under appeal. The case is over when all the appeal processes have ended. So how do you declare a seat vacant when the particular judgment is under appeal? I mean, it's just a basic legal question that I don't think that we should struggle with. Look, as it stands now, nobody can tell me that the decision of the court in Tamale is conclusive. It is not conclusive because it's under appeal. And then, of course, apart from the appeals court, there is one at the Supreme Court. So how, if it's not over, how do you declare the seat vacant? And that is the point that our leader alluded to. So clearly, they are just rushing. I think they are just in this indecent haste to organize the election, and it doesn't augur well for our democracy.
So the question people have been asking, people in the public domain, they are criticizing your side for the scenes we saw in Parliament yesterday. They say you could register your strong displeasure without the kind of scenes we saw in Parliament yesterday. Was that really necessary to be able to press home your demand? When you had made a statement which had been captured in the records, did you have to abstract Parliament from performing its responsibilities?
Well, I mean, protesting is a right that we have as members of Parliament. And the NDC has used it before, and we also use it. Look, the people of Ghana, if you are saying the people of Ghana are criticizing that, look, I mean, we are not above criticisms, right? And so we will take that in our stride. We wanted to achieve a particular thing. There are so many ways of doing that. They are suggesting one way, which is okay. We also felt that going another way is better. And yesterday we chose the path that we believe was going to get us what we wanted. And so it's okay. Them and all of that. So that takes some time. But look, we can all agree that this matter has to be heard expeditiously. And we will advise the lawyers if there is a need for them to do that. But when it comes to the Supreme Court one, I think it's on the 16th. That's okay. Now it's too late to now apply for abridgment of that. Why can't we just abide that time and then wait for the Supreme Court to make its decision? I think that in this instance, you all should defend us. You all should support us. That our position is right. And as the leader stated, there are so many cases that show that when a High Court judgment comes and there's an appeal, Parliament waits until the appeal processes are exhausted. Why is Pandai different? That tells you the kind of mindset our brothers on the other side have. And their deal is to get all of us out of parliament. But look, I don't believe that that's what the people of Ghana want. This is not a one-party state. It's never going to be a one-party state. We're going to stay in, fight, and protect the votes that the people of Ghana gave to us, especially the people of Pandai. They spent hours in the queue to go and vote. Okay, won the election by over 3,000 votes. We will protect that vote. We will assure the people of Pandai that their sweat will not go in vain. Their mandate, the mandate they gave to the people, to our brother Nyindam, will be protected.
Is there any challenge with Swami?